One of the frequent situations that we become involved in is where a client will come into the office and say, my dad is elderly, my mother passed away several years ago, dad is not fully in charge of his faculties, he's going on the internet every night and meeting unwholesome women, and we are concerned that he is going to give away or make gifts or dispose of a lot of his money to these people, and we really think that he ought to be protected against that. Is there anything that you can do for us?
If you do advance planning, you have a good power of attorney and advance directive, and you've designated who can handle your affairs for you if you're incapacitated. And very often that completely avoids guardianship. But if you haven't, and you become incapacitated, your family or your loved ones have an obligation to go to court and to protect you. To protect you both in terms of great access to medical care and the best medical attention you can possibly get, and in terms of preserving your assets. One of the fields in which I am an expert as an elder law attorney is in the field of guardianship. We try to avoid litigation at all costs. It's not always possible, but if you do need to litigate, we have the experience.
Frequently, the financial affairs of such persons are in a total state of disarray. They may not have filed income tax returns for the last 5 years. They don't know where their assets are. They don't know how they're held. One of the things that I can do in assisting Babette is to straighten out, to the extent possible, the financial affairs of the person who is somewhat diminished in capacity.